Welcome back, ladies and gentlemen, to the second half of this two-part podcast episode looking at IRAs. I am delighted to be joined still by John Bull at Blick Rothenberg. We have already in the first part talked about the income tax treatment IRAs, both for those living in the UK and those living in the US, and also for the individual account holder, but possibly a future recipient as well. We are going to turn our attention now towards what happens on death from a both tax and a succession perspective in both jurisdictions. So, John, looking at the consequences of death, I'd like to look, if we first could, at succession, because I think we need to give people a break from some of the income tax heavy stuff we were talking about previously. So, I, as a lawyer, when I'm talking about will drafting with clients, one of the things I want to know is what accounts does someone have, what assets does someone have, and I'm thinking about how those can be left on someone's death. And most commonly in the UK, we will do that via a will. In the US, it may be a will, it may be a revocable living trust. There are various ways to do it, and we're not going to get drawn into whether those are appropriate on this episode. Is an IRA a normal, quote-unquote, account that someone can leave in a normal testamentary way, or are there particular things we've got to think about in the US or the UK?
Yeah, great question, Aidan. So not in a not dissimilar manner to the UK with retirement accounts. US retirement accounts cannot be left via a will or a trust, or even titled into a trust during one's lifetime. There is a very specific way of passing on whatever is left at an individual's death, and that is via effectively a beneficiary designation form that the individual has on file with the provider of the account that dictates, right, I would like X amount to go to this particular beneficiary, Y amount to go to this particular beneficiary, etc., in a very clearly defined fashion, so completely separate to an individual's will or other estate tax planning that they might have in place.
And we will come on to some potential consequences of that, but from a succession perspective, is it like a typical UK pension where that is an expression of wishes, or is it in fact a binding declaration to which the institution that runs the IRA is bound into, or is the answer it's more complicated and it depends on each case?
I think it's more complicated. It depends on each case.
I thought you'd say that.
It depends on the provider, depends on the forms they've got in place, etc.
Fine. Before we do think about the tax consequences of someone passing away with an IRA, one final question on succession. I remember some years ago, I can't remember how many years ago now, there was a change to the rules on IRAs as to how long someone had to draw down funds from an IRA after they had received the benefit of one. Am I correct? That is still a 10-year period that you have to draw down the funds entirety?
Yeah, Aidan, that's right. 10 years. So this was the Secure Act that actually wasn't implemented that long ago, 2019. So much so that we still only have proposed regulations at the time of recording in terms of how the rules therein are supposed to operate in practice. But essentially, at a high level, means that for someone that is the recipient of an IRA on the death of an individual, rather than having choice over their lifetime as to when they draw down on that IRA, they now have to have fully drawn down the IRA within a 10-year period.
What are the consequences if that doesn't happen? Like if someone forgets, or let's say an IRA is discovered, or someone's just not got their paperwork together, is it that there are penalties for future withdrawals? Is it that, what happens if we do exceed that 10-year period?
I think this is where we're still waiting final regulations for exactly how that will operate in practice. 3 years is a fairly short period of time in US tax law.
Are we grandfathered into the rule? So if, let's say someone died in 2015, do I have until 2025 to draw it down, or is that rule only for people who've died after the regulations came into effect in 2019?
Yeah, so this is only for people that passed away after the implementation of the Secure Act. Yeah,
we've got till 2029. Then what are we worried about? The US has got loads of time left to
I think that's the view that the IRS is taking as well in terms of issuing some final regulations. Yes,
they may feel with their short-staffed numbers these days that they've got slightly more important things to be dealing with. But I'm sure for those who it matters, they'd quite like to see the answers to those. So let's think about tax at this point on succession. And I'm thinking largely about death duties, so thinking about estate tax in the US and inheritance tax in the UK, and to some degree how those interact with the income tax treatment. So an IRA, presumably, John, like a pension in the US, is free from estate tax on death, or is it chargeable as a normal account?
Yep. So IRA, the fair market value of the IRA on the death of the individual is treated as within the individual's estate.
And that's the case whether it's a traditional IRA or Roth IRA, or are we still only talking about traditional IRAs at this point?
Still only talking about traditional IRAs at this point. Yeah. So traditional IRAs absolutely within the remit of US estate tax, dependent on the status of the individual. We won't go into detail around estate tax. That could be the topic of, I imagine, 2 or 3 podcasts in themselves. But yeah, a current $12 million limit, and so whatever's in the IRA counts towards that limit.
And equally, an inheritance from let's say spouse 1 passes away and leaves spouse 2 the benefit of their IRA, that was always going to be exempt anyway. Is it possible to name successor beneficiaries if spouse 2 then passes away and it then passes down to the children? Can you leave it sort of on successive lives, or are you only allowed to sort of designate it once? And if so, what would the tax consequences be thereafter?
That's a good question. I imagine the answer is, although I've never dealt with this in practice, is that you can only designate once. So if you're the spouse of and have received an IRA, then you're then within, well, currently that 10-year period that you then need to draw down, and you can then make your own designation as to who that goes should you pass away during that period. If you request via this beneficiary designation form that IRA goes entirely to your surviving spouse, and you otherwise qualify for the US estate tax deduction as a result, then yes, the value essentially is then taken out of account for estate tax purposes by operation of the spousal exemption.
We'll leave that one as a write-in on a postcard for anyone who's feeling particularly keen and wants to write in. So let's assume we had the account holder was a US taxpayer. They were a US citizen, let's say, but let's say they are a UK individual. They were resident here in the UK. There is going to be the risk that individual is a UK domiciliary, or if not a domiciliary, then at least a deemed domiciliary. And so we need to think about UK inheritance tax on their death as well. Putting aside the application of the double tax treaty for one moment, the exposure of that account to inheritance tax is something that you and I have discussed previously. It is, in short, quite complicated based on the manner in which the UK treats pensions generally, and whether an IRA counts as a pension, a foreign overseas pension, for UK inheritance tax purposes. And the answer is, John, you're going to tell me, again, the lawyer and the accountant's favourite phrase, it depends.
It depends. It's difficult. It's complicated. Take advice. Yeah, of course. And yeah, what we've talked about before, Aidan, at great length, isn't it, is whether the IRA itself qualifies as qualifying on UK pension scheme, or the beautiful acronym, because we're in tax, we love an acronym, QNUPs. And if it does, then, well, we're in a great place, because we're potentially outside the scope of UK inheritance tax in respect to the value that sits within the IRA.
Yes, I think that's exactly right. And I think it is, again, a position where anyone who is left in that question needs to take the appropriate advice at the time. John and I are always hopeful that we can find that IRAs fall outside of an inheritance tax net, but there is no given. What we will say as a tease to some of the reasons why is to throw it back to a comment we made a few moments ago about the nature of the beneficiary designation on the IRA. There can be a difference between a memorandum of wishes, a non-binding expression of who you want your assets to pass to, or who you want the IRA to pass to, and leaving a binding declaration. So for those who are thinking of getting in touch, I would imagine John would agree with me that one of the first things that we're going to want to be asking, and thus looking for, is, do you have a copy of that declaration, that expression of wishes? Can we see it? Because it might be that is something on which it turns. So let's assume this person, though, was a US citizen living in the UK. We don't just have the US-UK double tax treaty, which deals with income tax. We now have the capital taxes treaty between the two countries, which deal with estate tax and inheritance tax. If we were to find that, for example, an IRA is within the inheritance tax net, but is outside of the estate tax net for the US, if this person is a US domiciliary and let's say is a UK domiciliary at the same time, can we rely upon the a US primary rate of taxation in the right circumstances to override the inheritance tax exposure? My gut is probably not, because the US has not taxed it specifically, because it not just because it falls under the allowance, but also because it's an exempt asset itself. But again, there are so many variables here. It is possible in a circumstance that it may be exempt in both countries. Would you agree? It just requires investigation.
Yeah, completely, Aidan. Yeah, we're really into the scope of something that's completely incredibly complex. But yes, there is a comprehensive capital taxes treaty between the two jurisdictions, in the same way that there's a comprehensive income tax treaty. If someone is deemed domiciled in the UK but still a US citizen, then, as we've talked about again on a number of cases, primary right to tax typically falls with the UK, subject to the type of asset we're dealing with. If we're dealing with an IRA, then the natural follow-on process from that is that it is very difficult then to take the value of the IRA outside the scope of UK IHT by using the treaty, if we can't somehow look at the QNUPS exemption that we talked about just now. But it's an incredibly complex area.
And this is one of the few places in my discussions with clients where I have to deviate from my general position, where I say the Americans love taxing by citizenship, and your desire to pick up UK citizenship has almost no bearing on the extent to which you are taxed as an individual in the UK. And some of the provisions of the capital taxes treaty between the US and the UK are the reason why I insert the word almost into that, because it can be in these circumstances that being a UK citizen brings the UK right to tax back into contention. So this is why I sometimes like to say almost no impact on your right to tax, on the UK's right to tax. Certain circumstances, it can actually play against you. There's one final question I would like to ask you about tax on death, which is the scenario that I have had put to me several times by UK people who inherit an IRA who are not themselves a US taxpayer, which is, if the individual who died is domiciled in the UK or deemed domiciled, and let's say inheritance tax is potentially chargeable on the account, that inheritance tax is going to be levied at, taking aside nil rate bands, 40%. That individual in the UK is then also going to suffer income tax on drawing down in the manner which we've described previously. So we potentially have effectively double taxation on the same funds because of the way in which the UK considers this to be a pension for income tax purposes, but potentially not a pension or a QNUPS for inheritance tax purposes. In this scenario, is there anything that can be done, or is that individual just at the mercy of an unfortunate gap between the two taxes of the two jurisdictions?
Yeah, it's a question I was really hoping you weren't going to ask me, Aidan.
The answer may be what you said previously, which is I put your own hypothesis back to you. If a lump sum were drawn down in the US, then the US would have the primary right of taxation. You're going to suffer US taxation. You're going to suffer US income tax on the withdrawal, and you're going to suffer UK inheritance tax. If you take a income distribution, you're going to suffer UK income tax and UK inheritance tax. Is one of those better than the other or not? I think it probably isn't going to make much difference, absent the fact that the US marginal rate of tax on your income is probably going to be slightly lower. So you might be better off taking a lump sum distribution.
It's a very good point. But I think the point you made at the start, which is we're effectively facing double tax here, between a capital transfer tax and then income tax on the back end, which is something that naturally we'd want to think about avoiding if possible. But I mean that scenario does present itself if we're dealing with a regular IRA and an American, and we don't even touch the UK because yes, the asset is subject to estate tax, but for the recipient, it is then also subject to income tax when distributions are made. So there is in that effect there is a double tax, an element of double tax there, because we've got estate tax on the death of the individual and then income tax when funds get paid out. So it's something that certainly is envisaged, but as between the US and the UK, it's complicated.
I think if we could think of any tagline for our respective practice areas or for this podcast, I think US and UK tax : it's complicated. I think I could do a lot worse than use that as a tag. John, thank you so much for your time today, for speaking to me and to speaking to the audience about IRAs. If I might do John the benefit of plugging his work, if you need to seek the advice of US, UK tax advisors, or for that matter, if you are not an American and want to seek the advice of accountants anyway, I'm sure John would be happy to introduce you to his non-US UK colleagues. But please do go and find them on undoubtedly their website. They will have more information. Equally, if you have any questions for Colin Bristow, please don't hesitate to get in touch. Otherwise, John, thank you so much for coming.
Thank you very much for having me.
And we will see you all next time. Thank you very much.